Welcome to SCOTUScast, Speedy Trial Right and Sentencing Delays Edition. Thank you for tuning in. On March 28, 2016, the Supreme Court heard oral argument in Betterman v. Montana. Brandon Thomas Betterman pled to and was sentenced for the offense of bail jumping. He argued on appeal that a 14-month delay between the entry of his guilty plea and his sentencing violated his Sixth Amendment right to a speedy trial. The Supreme Court of Montana affirmed Betterman's conviction and sentence, holding that the constitutional right to a speedy trial does not extend from conviction to sentencing. A criminal defendant still retains, the court concluded, a 14th Amendment due process right to have sentence imposed in a timely manner, without unreasonable delay, and the delay in this case was unacceptable, but any resulting prejudice to Betterman was speculative and not substantial and demonstrable. The U.S. Supreme Court subsequently granted certiorari on the following issue: whether the Sixth Amendment Speedy Trial Clause applies to the sentencing phase of a criminal prosecution, protecting a criminal defendant from inordinate delay in final disposition of his case. To discuss the case, we have Anthony Johnstone, who is Associate Professor at University of Montana Alexander Blewett III School of Law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Professor Johnstone.
The Sixth Amendment to the United States Constitution begins, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury." Under the Sixth Amendment, Betterman against Montana presents a surprisingly open question of criminal procedure: whether the Sixth Amendment speedy trial right applies to sentencing. In other words, what does the Constitution mean by trial? I should note at the outset that I consulted on this case with the state of Montana, though in this podcast I speak only for myself. In December 2011, Brandon Betterman failed to appear in Butte, Montana for court on felony charges of partner or family member assault. He turned himself in February 2012, explaining that he lacked the money to travel the more than 200 miles to Butte from his location in Billings, Montana. That March, the state court sentenced Mr. Betterman to prison for 5 years with 2 years suspended on the assault charge. The state also charged him with bail jumping. The following month, in April, Mr. Betterman pleaded guilty to the bail jumping charges. The court remanded him to the county jail to await sentencing on the new charges and ordered a pre-sentencing investigation. That pre-sentencing investigation was completed in October 2012, and the court scheduled a sentencing hearing in January 2013, 9 months after his guilty plea on the bail jumping charges. On the day of that hearing, Mr. Betterman filed a motion to dismiss the bail jumping charges, alleging he was denied a speedy trial due to the delayed sentencing. After the state took an opportunity to respond, the judge denied the motion in April 2013. Meanwhile, with the anniversary of Mr. Betterman's guilty plea approaching, both the state and the defense asked the court to set a sentencing hearing. In May 2013, 13 months after his guilty plea, Mr. Betterman filed an affidavit complaining of his lack of rehabilitation opportunities at the county jail and of his increasing anxiety at the delayed sentencing. Finally, in June of 2013, the court sentenced Mr. Betterman to prison for 7 years, with 4 years suspended, to run consecutively to his prior sentence. It had been 14 months since his guilty plea. Mr. Betterman appealed to the Supreme Court. That court once had held that the state and federal constitutional rights to a speedy trial applied to sentencing. It re-examined that precedent in Mr. Betterman's case and overruled it, holding, just as the right to speedy trial does not attach until a criminal proceeding has been initiated, or after charges have been dismissed, so too does it cease to apply when the conviction becomes definitive. Instead, the court analyzed Mr. Betterman's claim under the Due Process Clause, which, it reasoned, protects a criminal defendant from unreasonable delay between conviction and sentencing. It held that although the delayed sentencing was unacceptable, the delay did not substantially prejudice Mr. Betterman, and it affirmed the sentence. The United States Supreme Court granted Mr. Betterman's petition for certiorari. Mr. Betterman, represented by Fred Rowley of Munger, Tolles & Olson, frames the question presented as whether the Sixth Amendment's Speedy Trial Clause applies to the sentencing phase of a criminal prosecution, protecting a criminal defendant from inordinate delay in final disposition of his case. Starting with the text of the clause, Mr. Betterman argues the word trial includes the full course of a prosecution, from charging through sentencing. He puts the word trial in context, noting the Sixth Amendment requires both speedy and public trials, and the court has suggested the public trial right extends beyond the trial itself. Mr. Betterman also looks to history and the practice of unitary criminal proceedings with fixed sentences at the framing. This, he argues, reflects the common law guarantee of full and speedy justice, including sentencing, and not merely the verdict. Finally, Mr. Betterman argues the speedy trial right's extension to sentencing is consistent with this clause's purposes. Like pre-trial detention, pre-sentencing detention usually occurs in a county jail, which may be oppressive and deny the defendant rehabilitation services available in prison once sentenced. In addition, given the prevalence of guilty pleas, sentencing may be the only contested stage of the criminal process, and delay may impair the defendant's case for a lighter sentence as time passes for witnesses like his family, the community, and victim. Lastly, an unreasonable sentencing delay may cause just as much anxiety in a defendant who is awaiting his sentence as it would for a defendant who is awaiting trial, given possible uncertainty about the sentence's severity and conditions. The National Association of Criminal Defense Counsel joined Mr. Betterman's side, focusing on the purpose of speedy trial protections and the inadequacy of existing doctrine to remedy sentencing delays. Montana, represented by State Solicitor General Dale Schoengert, also turns to the text, history, and purpose of the Speedy Trial Clause to argue against its application to sentencing. First, Montana highlights the full text of the clause, which guarantees the right of the accused and not the convicted. And the trial right includes the guarantee of an impartial jury, which applies only to the determination of guilt and not sentencing. Historically, Montana argues, the trial process concluded at the verdict. Next, Montana explains that the historical function of the speedy trial right was to ensure a potentially innocent person accused of a crime could clear his name quickly without undue delay. According to Montana, this protection for the accused underlies the right to a speedy trial, and not any broader concern for administering justice without delay. Once the accused presumption of innocence was lost upon a guilty verdict, Montana argues, the balance of justice shifted away from expediting the criminal proceeding. Finally, given the historical function of the Speedy Trial Clause, Montana rejects the analogy of the clause's purposes to sentencing. Montana argues there's little evidence that today's jails are categorically more oppressive than prisons, particularly because prison overcrowding leaves many prisoners in jails anyway, and jails often are closer to a defendant's home community. Montana also argues Mr. Betterman overstates the prejudicial effect of delay to a defendant's arguments for a lighter sentence, because few factual issues actually arise at sentencing. If post-trial delay prejudices sentencing, why wouldn't similar delays on appeal and collateral review raise similar issues? Lastly, Montana argues, the nature of a convicted defendant's pre-sentencing anxiety is fundamentally different from an accused defendant's anxiety awaiting trial, given the presumption of innocence ends with the verdict. Montana raises another issue, that of remedy. The conventional remedy for a Speedy Trial Clause violation is dismissal of the charges. Such an extreme remedy in a case of delayed sentencing would be especially inequitable, given the defendant's guilt will be established. Instead, Montana argues, the court should follow the Montana Supreme Court and other courts to have rejected the speedy trial claims at sentencing. It should apply a more general due process standard and invoke the more flexible remedies available for prejudicial delay under the Due Process Clause. The United States, represented by Assistant to the Solicitor General Ginger Anders, joined Montana's side in the briefs, amplifying the textual, historical, and purposive arguments, while also acknowledging that federal criminal procedure generally guards against undue delays in sentencing. 17 states, led by Indiana, also joined Montana's side, reiterating the windfall to defendants that could result from a finding of a speedy trial violation in sentencing, and explaining the statutory measures states have taken to reduce delay at sentencing. On March 28, 2016, the Supreme Court heard arguments in the case. Relatively few of the justices' questions concerned the textual source of the right and remedy at issue. Here, Justice Scalia's recent death left a clear gap in the discussion, given his well-developed originalist jurisprudence of the Sixth Amendment. Justice Alito engaged most with the text and history of the Sixth Amendment, noting the connection between the meaning of trial and the role of the jury, and disputing Mr. Betterman's suggestion that pre-sentencing delay under indeterminate sentencing was uncommon at the time of the adoption of the Sixth Amendment. Justice Kagan, however, questioned why the right shouldn't be drawn from the Sixth Amendment, observing, "It seems a very odd place to park this right and this remedy, the Due Process Clause." Yet Justice Kennedy seemed to indicate the direction of several justices when he noted, if only because of 14th Amendment incorporation of the Speedy Trial Clause, liberty is involved, as a matter of due process in any event. Justice Breyer added, "I don't see a problem with liberty." Yet Justice Sotomayor noted Mr. Betterman had not brought the due process claim to the court. So instead of the meaning of the Speedy Trial Clause itself, the court focused on the legal standard applicable under any constitutional guarantee against undue delay in sentencing, and in particular the level of prejudice required to show a violation. Mr. Betterman argued that only the speedy trial factors developed in the Barker against Wingo case, which balance prejudice alongside other factors, adequately account for the harm of pre-sentencing delay. Questions from Justices Breyer, Sotomayor, and Kagan sounded supportive of this argument. Montana contested the application of the speedy trial factors, and in particular their consideration of prejudice as just one factor among many. Given the shift from accused to convicted that occurs after a verdict and before sentencing, some amount of actual prejudice should be established, Montana argued, particularly because any remedy short of dismissal would need to ask just what harm must be remediated. Chief Justice Roberts sought and received confirmation that it is typical in both state and federal courts for judges to credit time served pre-sentencing, perhaps an indication of his skepticism that prejudice often results from even extended pre-sentencing delays. Similarly, Justice Alito noted most facts relevant to sentencing are determined in pre-sentencing investigations, not at sentencing hearings, a suggestion that he also may view the speedy trial test as inapt. At oral argument, the United States supported Montana's argument that prejudice must be established and offered a test drawn from other due process cases in criminal procedure. That is, prejudice is established where there's a reasonable probability that the outcome would have been different but for the constitutional violation. In this context, that would mean the defendant probably will serve a longer sentence than he would have without the delay, except, importantly, in capital cases. The United States was prompted by Justice Kagan to concede that a speedy trial analysis may still be appropriate in capital cases, given the analogy of capital sentencing to trial. In conclusion, the question that most divided the court is the standard of prejudice that must be established for a constitutional violation. Can a defendant rely primarily on an exceptionally long delay in sentencing and the resulting anxiety, lack of prison services, and potential difficulty in preparing mitigating evidence? If so, do these harms merit a reduction in the sentence, and how should a judge determine such a remedy at a delayed sentencing? Or must a defendant seeking a reduced sentence establish prejudice, meaning the delay itself likely led to a longer sentence than he otherwise would have received? The answer to these questions may turn on whether the court finds the solution to the problem of excessively delayed sentencing in the specific guarantee of a speedy trial and its distinct and ancient concerns about justice delayed, or in the general guarantee of due process of law and more practical concerns about prejudicial deprivations of liberty.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.